Subject to Lordship's kind sanction.
Yes, please.
Item number 71 and 73. Lord, we are facing the contempt. Lord, let it be taken up on Monday under the heading fresh matter, because these are the fresh matters, my lord.
Fresh matters.
Fresh matters.
71 and 73.
My lord. 73, 71 and 73 analogous matter.
And who will be appearing for the respondent?
My lord, I have served, but my lord, again, I will inform.
You inform that it will be upgraded.
My lord. I'm great.
We will see how we progress today.
Because my lord, we are facing the contempt rule for such. I'm great.
Yes, please.
Lordship, may I mentioning for the correction of the order?
Correction.
Correction of the order.
To give it to be mentioned. Yes, please call the list.
Daily list, serial number 1.
I am for the petition. I am for not pressing the application.
I appear for the statement.
You are giving a letter or something?
Don't have the letter, Lordship.
The learned
filed the fresh
the appellant submitted that.
Side.
And he has instructions from his client. He has instructions from his client not to press this appeal. They said the submission is placed on record and dismissed. The appeal is dismissed as not pressed.
Serial number 2.
I am for the respondent lead petitioner, my lord.
May I appear for the respondent number 7, my lord, but
I
do not know why the matter is appearing under the heading to be mentioned, but no notice was served.
Not know, my lord, on whose instance the matter is appearing at.
We also don't know what to.
Yes, my lord. No notice, nothing served to us.
Your Lordship, I am appearing for the applicant.
Yes. Learned advocate mentioned that there is a mistake in the name of the respondent in the cost title. As a result, she can't file her wakalatnama. And which is that respondent, madam?
Your Lordship, the appellant number 1 was the respondent number 6 in the writ petition, Manas Mukherjee.
It should be?
It should be Manas Banerjee, Your Lordship.
Oh, that mistake is there in the cost title?
In the cost title of the writ petition, which is why it has been reproduced in the appeal. And as such, I am unable to file the wakalatnama, Your Lordship.
Is there any record to show that it should be Manas Banerjee in the writ petition?
Nothing in the writ petition.
So we can make that correction so that she can file her wakalatnama. Matter has been listed under the caption to be mentioned.
So in the cost title also, your lordship, it was Manas Mukherjee.
Yes, that's what she says. That's a mistake.
Yes.
You submitted that the name of the first respondent, first appellant / respondent number 6 in the writ petition has gone down wrongly as Manas Mukherjee, but the correct name is
Manas Banerjee.
This mistake has occurred in the cost title in the writ petition as writ petition. As a result, in this appeal, the cost title has been shown as in the writ petition. Since this is a mistake which is not being disputed, the name of the first appellant is corrected as Manas Banerjee, and the necessary correction be made in the cost title. The learned advocate is entitled to file the wakalatnama on behalf of Mr. Manas Banerjee.
Your Lordship, I am seeking one more indulgence. Your Lordship, I have received a notice of contempt from the respondents. Let the matter be listed as an upgraded motion on any day convenient to your Lordship.
Monday cannot be on Tuesday.
Tuesday, residual matter.
Next Wednesday.
Next Wednesday. Grateful, your
It's
Lordship.
the matter for admission next Wednesday.
Serial number 3.
In this matter, I am appearing for the applicant.
Yes.
I am appearing for the
For the
respondent.
Alice contempt normal.
My lord.
I have served the notice. If it was service yesterday, I filed as per my lordship's direction.
Let us see the
intimated
order.
to the
My lord, my lord, I am being instructed by the respondent that while traveling today, he got injured in his hand, and then I am praying for not today on his behalf. He's an advocate. He will appear in
This
person,
is
my
the
lord.
contempt matter. This is the personal appearance on 8th.
The respondent is an advocate, my lord, and he will appear in person. So for
I
that,
did-
he is pressing not today. He will appear tomorrow.
There are
my
two applications, my lord. Can number 2, my lord. That is the section 5 application. 40 days delay. Due
lord-
to changing the lawyer, my lord, the 40 days delay.
My lord, if the matter will be listed
I'll
tomorrow,
appeal in due time.
If the matter will be listed tomorrow, then my,
Tomorrow it won't come.
the day after tomorrow, my lord.
Tomorrow is PIL day. Day after is original side.
Ma'am, any other date,
Next
my lord.
Wednesday only it will come.
Any other date, my lord. He's an advocate. I have
The
been
thing
in.
is personal appearance we will
Personal, yes, my lord. Personal appearance.
we will do one thing. The personal appearance we will dispense it with for a week. We will list the matter for admission next Wednesday.
Ma'am, even ma'am, what I have been instructed that the matter has been mentioned yesterday, but there was no prior intimation regarding the mentioning was served upon us.
No, before filing this, I served
The
this notice. I mentioned
my
in
lord,
the
appeal,
service.
my lord,
Even today, my lord, yesterday
lord,
I intimated
all right.
the mail.
appeal was served, but no prior intimation regarding mentioning was served.
The learned advocate for the appellant
Learned
and the
advocate.
learned advocate for the appellant. The respondent is a practicing advocate before this court who's to appear in person in the matter, and on account of certain inconvenience, he is unable to appear, and a representation is being made by a learned advocate on his behalf, seeking for an adjournment. The learned advocate for the appellant submitted that contempt petition has been filed, and the public information officer has been directed to appear before the learned single bench on 8th. On 8th, no?
On 12th.
On what date he has to appear?
My lord, 8 April 2000.
On 8th April 2024.
That is on Friday, next Friday week, my lord.
No, Monday.
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 Yes.
Since adjournment is sought for on behalf of the respondent petitioner, let the matter be listed on 10th April 2024. On
My lord, on 12th of April, I guess.
12th, yes.
12th of 10th April 2024. In the meantime, the personal appearance of the public information officer may not be insisted. List on 10th April, the
Grateful, my
same
lord.
position. Next.
Serial number 4.
DP
My lord, I am appearing for the appellant petitioner, my lord. This matter, my lord, involves a question of national security. Because why I say this, my lord, because the impugned order, the honorable single judge has held that any person, whether he is an illegal immigrant or not, he can enter India and apply for citizenship. That involves a question of national interest, my lord. May I file my affidavit of service? The impugned order, page double. Impugned order is that, my lord, if my lords kindly take up my CAN application. Impugned order of 24th February 2020, page 140. Citizenship Act. The legislative intent is very clear as per section 5 of the Citizenship Act that an illegal immigrant cannot apply for citizenship. In this case, what has happened, the basic fact is that the petitioner, writ petitioner is a Pakhtun national. Pakhtun means, my lord, part of Afghanistan and northwest frontier province of Pakistan. It's an illusory country. It is not recognized by the United Nations. He is saying that he is coming from Pakhtunistan and entered India as an illegal immigrant and applied for citizenship. He is staying in India for long and so is entitled to that. And the Honorable Single Judge has held that requirement of passport under the Act is not a mandate. That is wrong. That is where we join in issue. May I place section 5 of the Act? That is where we join in.
Here the appeal respondent has been served.
Yes, I filed as affidavit of service.
So,
We are facing contempt also. I am praying for an interim protection also.
all right.
But
We have heard the learned advocate for the appellant. The respondent has been served and affidavit of service has been filed, which is taken on record. None appears for the respondent. In this appeal, question of law has been raised for consideration as to whether the requirement of having a passport to be entitled to apply for citizenship in India is an optional requirement, and whether the learned writ court was right in holding that such requirement has to be read as optional in Form Roman 3 of the Citizenship Rules 2009. Citizenship Rules 2009, and that the authorities are deemed to have the power to relax such requirement in the event the applicant satisfied the authorities for genuine reasons why the applicant is not in a position to produce such passport. Since the finding rendered by the learned writ court could have a wider impact, we are inclined to entertain this appeal. Accordingly, the appeal is admitted, and there will be an interim stay of the order and direction issued in the writ petition in its order dated 24/2/2020. Let the matter appear under the caption for directions on 15th May.
My lord. 15th. My lords, I'm praying for an interim protection.
Yes.
Oh, my lord, I'm extremely grateful to you.
Serial number 5,
Yes.
Advocate Juidota Chakraborty is appearing for the appellant. Today, her mother-in-law chemo and immunotherapy to unable to come to the court. So I am praying for not today.
You are not ready.
No, my lord.
I think the direction is correct, sir. Once that online registration process is there, and they have also given the password or whatever the registered mobile number, you can download the copy. The downloaded copy is as good as original, and your appeal under the RTA Act is still pending. And this is clearly a civil matter, because whether she is entitled for a copy of it, anybody can download. But anybody can download the copy.
My lord, there is a specific mobile number.
That
In
number
the-
has been given to the petitioner.
Mobile, actually, there is a dispute within the parties themselves. That is the problem. They cannot get any downloaded application from that mobile number.
So the
That-
mobile number is with the niece,
With the other, yes.
other lady.
And there is a dispute between both the parties.
And the
Both
appeal
are
under,
heirs,
appeal under RTA is still pending.
still pending.
Why can't you dispose of that appeal?
If your lordship so directs, I can do it.
Whether the appellate authority is a party in the,
No, that was also a point. The appellate authority is not a party, my lord. Actually, here, my lord, the commissioner is not made a party.
but why is the death certificate not available in the public domain? Why only particular registered mobile See, legal, if he is, the petitioner is a legal heir, then automatically,
No,
no.
so far, no, he is not illegal here. That is also not.
Oh, he claims to have a joint account with the
Yes,
deceased.
yes. For that reason, for the bank account, he is claiming that.
And what is the relationship with the deceased? He is a stranger.
Stranger. He cannot.
And where is the appeal petition?
I have got the writ petition just now, they have supplied me the appeal. That is P12, my lord, page 68. That appeal is pending before the State Public Information Officer. And that is not our party, that is State Public Information Officer.
And who is this Soma Sengupta? Appellant here is, oh, second appellant. Wife of Ashish Sengupta.
And the joint account is in the name of the petitioner, appellant. And
This intra
he is not an heir of that.
directed against the order dated 12/5/2023 in WPA 5753 of 2023. The writ petition was dismissed on the ground that on principally two grounds, that the appeal filed by the second appellant before the State Public Information Officer, Howrah Municipal Corporation.
No, State Public Information is not the Howrah Municipal Corporation. That is the State Public Officer. That is not.
The State Public Information Officer, Health Department,
Yes, sir.
dated 21/12/2022 is pending. Apart from that, the learned writ court has also held that the appellant's writ petitioners were time and again directed to the web portal and given the registered mobile number through which the appellants could have downloaded the death certificate, and that the appellants have not done so. Furthermore, the learned writ court held that there is no provision to pass a mandamus on the respondents to make an exception to the online registration process and give a hard copy of the death certificate to the petitioners. In our view, since appeal is pending before the State Public Information Officer, the appropriate course to be adopted by the appellants is to pursue such an appeal and take the matter to the logical end and not invoke the writ jurisdiction of this court, as it will tantamount to a parallel proceedings. Therefore, this appeal stands disposed of by directing the appellate authority, namely the State Public Information Officer, to dispose of the appeal petition filed by the appellant, sent through speed post on 21/12/2022 as expeditiously as possible, preferably within a period of 4 weeks from the date of receipt of the server copy of this order. In order to facilitate the State Public Information Officer to dispose of the appeal in terms of the above direction, the petition appellants are directed to submit a copy of the appeal petition along with a copy of this order and submit the same in person in the office of the State Public Information Officer to enable compliance in the above direction. The appeal accordingly stands disposed of. Next.
Grateful, my lord.
My lord, with utmost humility, my lord, I pray apology before your lordship, my lord. In item number 4, my lord, there was a delay for COVID pandemic period.
Delay can be
My lord,
I'm
kindly some time,
3 weeks.
3 weeks.
3 or 4 weeks here.
Serial number 6.
Should I appear for the appellant?
In this matter, my lord, I am appearing on behalf of the, my lord, respondent,
My lord,
writ petitioner, my lord.
I am for the applicant 6.
But I'm
No,
always
name
scared
the law.
when Mr. Mukherjee is beside me.
Don't embarrass me. My maiden appearance before your lordship, my lord.
Lord, in this matter, my lord, I appeal on behalf of the NIA, my lord.
Pardon, sir?
On behalf of the NIA, my lord.
NIA.
Afterwards, my lord, investigation was transferred to the NIA.
Ah.
My lord, we asked for the certain copies of the documents for the purpose of carrying on investigation pursuant to the order passed by the Honorable Single Judgment. But that was not done, my lord. Contempt proceeding was initiated, my lord. Contempt rule was issued, my lord. Thereafter, my lord, they have mentioned this matter before your lordship, my lord. 5th is the date fixed, my lord.
5th.
This is there are materials, my lord, on the basis of which
It was rendered on 10th of
yes.
on 10th of May.
Yes.
Thereafter, they did nothing, my lord. They filed an application for contempt against us also and also the state officials. My lord.
But in
We,
fact,
my lord,
Lord,
we,
your
my lord,
lordship
submitted
recollect,
before
my lord?
we, my lord, submitted before the court that we are not guilty of contempt because we are asked by letter to hand over all the relevant papers so that we can carry on investigation as directed by the honorable single judge, my lord. But that was not so. Our names were, my lord.
No, in terms of the direction, you have registered an FIR.
No, my lord, because if we do not get any, my lord, documents, we cannot proceed. Thereafter, my lord, they did nothing. Even in the appeal, my lord, they have not made us party, my lord.
No, he was not a party before
Because that time, my lord, that time they did not appear with the
I cannot, my lord.
My lord,
Yes.
in the memo, if you'll also kindly see, here, my lord, National Human Rights Commission has also been made party. The appeal itself is defective, my lord. NHRC was party, my lord, all along in the writ application, my lord.
NHRC. But that can be corrected, my lord, because initially, my lord, NHRC was not a party, my lord. The learned single judge had directed NHRC to be made a party, my lord. This is a, my lord.
This is a case of bombing.
Yes.
Well, that is what has been said. But, my lord, my primary two, my lord, points are, number one, my lord, the honorable single judge, my lord, has relied upon a report of NHRC, ignoring and even holding that the NHRC did not have any jurisdiction in view of, my lord, section 36 of the Protection of Human Rights Act, that if the state Human Rights Commission has initiated a proceeding, NHRC does not have any jurisdiction. My lord, the learned judge has held. And thereafter, the learned judge says that though they have no jurisdiction, but certain observations are there, which the learned judge has relied upon in coming to the conclusion that this should be transferred to the NIA.
Who was the writ petitioner? The victim's father or something?
Yes, father.
Victim's father.
Father. I appeared, my lord.
You appeared.
Yes, my lord.
The primary prayer was, the primary prayer was to transfer the investigation to CBI.
That was not granted.
That was not granted. But, my lord, relying upon, my lord, the NHRC report, my lord, please consider, my lord, whether it can be transferred to a third agency. My lord, charge sheet has been filed. There are 33 accused persons. My lord, the grounds for transfer of investigation not satisfied. But, my lord, the learned single judge felt that, my lord, this should be done.
Done by NIA.
By NIA.
After 5 years.
And that too, my lord, after 5 years. My lord, if your lordships may kindly, my lord, have a look to, my lord, 2 or 3 paragraphs, my lord, of the judgment of the learned single judge. My lord, if your lordships may kindly take, my lord, paragraph 46 of the judgment.
Yes, we have got.
May I place only this? Indeed, the State Human Rights Commission had taken cognizance of the incident on 25th of September 2018, that is 3 days before the NHRC swung into the matter. A plain reading of section 36 of the PHR Act could not clearly indicate that there was a clear bar of NHRC in inquiring into the incident after the SHRC had taken cognizance of the same. Then, my lord, the NC Dhautial's judgment is considered. Now, kindly have a look, my lord, in the quoted portion. My lord, quoted portion, my lord, in the bottom of that page 20. The last quoted paragraph, section 36. 2 of the Act thus places an embargo against the Commission inquiring into any matter after the expiry of 1 year from the date of the alleged act violative of human rights, etc. Then, my lord, skipping over a few paragraphs, my lord, please take quoted para 17. This was a completely different case. The bar under section 36(2) is sought to be got over by the Commission by invoking the theory of continuing wrong and recurring cause of action. So, but this was a case completely, my lord, on a different point, that whether, my lord, there can be, my lord, an assumption of jurisdiction after, my lord, period of 1 year, my lord, which is an embargo under section 36.
That the learned judge accepts in para 47.
Right.
But the learned judge says,
yes,
the said report of NHRC, however, assumes some relevance and importance from a complete different standpoint before this court, given the conduct of SHRC.
Now, but this is the point for determination by the Honorable Division Bench, as to whether, my lord, if NHRC did not have jurisdiction, but whether, my lord, an observation could be looked into. But if the NHRC did not have a jurisdiction, but the entire report cannot be looked into. This would be, my lord, my first respectful submission before my lord. My lord, parts of that report, my lord, in my very respectful submission, my lord, cannot be, my lord, looked into, my lord, by the honorable single judge, my lord, for the purpose of, my lord, coming to any conclusion. Now, my lord, please, my lord, have a look to, my lord, paragraph 49.
Yes.
Here, my lord, says that the SHRC was indolent. Kindly have a look to, my lord, paragraph 49.
48, they extract the
Yes,
three-judge bench.
right, in Abdul Sattar.
In fact, I was heading this bench.
Yes.
I see.
Abdul Sattar. So I got transferred. So therefore, the composition had to be
changed.
reconstituted.
I see. Now, my lord, after that Sattar, please look, my lord, para 49. From the 21st of September 2018 till date, the SHRC has been guilty of complete inaction. They have neither sent a team for the spot inquiry nor have chosen to inquire into the matter despite specific powers conferred by section so and so. The SHRC only sought reports from DM, the DG and CID, SDO and SP for nearly 5 years. The last of such reports were received by SHRC on November. There was therefore been an abject failure and complete abdication of statutory responsibilities by so and so. The lame defense for such inaction of the SHRC advanced on affidavits and argued by the council on their behalf to say the least is ridiculous. There was no functional chairman of NHRC from 2020 onwards until 2022. This would ipso facto mean that the SHRC was fully functional, having quorum from 2018 to 2020. As to why the SHRC was reluctant to send a team to the spot has remained absolutely inactive, even as on date, despite a statutory mandate under section 36, remains unexplained. Counsel for SHRC argued that NHRC was already in the field and taking steps. They did not want to interfere with or interrupt the inquiry of NHRC team. The court is therefore left with no other option than to consider and entertain the report of NHRC.
Can it not be taken as a fact-finding report?
Look,
Assuming, the learned judge faults the State Human Rights Commission for having not taken any action, and whatever defense they have raised before the court was rejected as a lame defense. So therefore, undoubtedly that report is available. That report has not been scrapped. Probably in terms of by operation of law, NHRC might have exceeded jurisdiction by entering into the matter after a period of 1 year. The larger question would be how to compute the period of 1 year. What will be
From when?
From when? But nonetheless, that report is there.
may I say this, Milord?
So that report, the learned judge at page 30
Yes.
has culled out certain important observations.
Yes. But my respectful response to Milord, your lordship's query is, Milord, the NHRC or SHRC, Milord, they are, Milord, bodies sui juris. Milord, they have to act, Milord, within the four corners of the state.
Read the larger bench judgment of the Madras High Court. All those aspects have been discussed in.
But in fact, Milord, if your lordships recollect, Milord, my lords have been pleased to, Milord, uphold, Milord, a judgment of Justice Soposhachi Bhattacharya, this honorable bench, where, Milord, this point was discussed whether, Milord, NHRC could, of its own, ignoring the statutory provisions, can entertain. Milord, your lordships were pleased
State
to.
Election Commission matter.
Yes, State Election Commission matter. My lords were pleased to hold, Milord, that no, NHRC does not or cannot go beyond the statute. Now, Milord, if it goes beyond the statute,
What happened?
Milord, this embargo applies to both NHRC as well as.
But then the appeal has to be heard.
Yes,
Yes,
Milord,
yes.
Milord, your lordships kindly hear out the appeal, Milord. I have got,
But
Milord,
then
other
in
points.
the incident occurred in the year 2018.
Yes.
And to grant a stay of this direction now, it will frustrate the entire object. Imagine the plight of the victim's family.
Milord, could I say this?
Till
Milord,
date,
to your lordship's
my
permission?
lord, 2 bodies are, my lord, kept under, my lord, in custody.
2018.
Yes, my lord, for want of second postmortem, my lord.
That was long, Milord.
Two childs.
To that, there has not been any appeal.
No, you please hand over the records,
Yes.
let them register the FIR,
Madam.
because they are also facing contempt, you are also facing
Well,
contempt.
could I make this suggestion subject to?
And we will hear out the appeal, probably investigation may take some time, you succeed in the appeal, we will scrap the transfer.
Milord, could I say this, Milord? Milord, more or less, Milord, all papers are before the court, Milord. If your lordship may kindly find out sometime, Milord, next week, Milord, we can come and Milord, set out all the points.
But in the meantime, you please hand over the documents.
But Milord, then Milord,
Because
the appeal becomes academic.
It's a 41 page judgment.
Yes, yes.
The appeal
But
has to be
I
heard.
cannot, Milord, invite the court to hear
No,
out the
if
entire.
suppose we have to grant stay, we have to record specific reasons,
Yes.
saying that for such reasons, we find prime facie case has been made out. But prime facie, we are the opinion that the findings or the findings of fact recorded by NHRC has not been scrapped till date. So that the court, can you ask the court to ignore such findings?
Milord, may I say this, Milord? If, Milord, that report is not a valid report, or, Milord, if the assumption of jurisdiction is contrary to law, Milord, please consider, Milord, whether that report is.
No, under the provisions of the Act,
Yes.
they can approach the Supreme Court for implementation,
Right,
the recommendations.
right.
But here the learned judge says, since they have been made a party, therefore we are entertaining that prayer. Where did I say this?
Milord, this your lordship will find, Milord, towards the beginning of the judgment.
And whether prejudice to the state administration, that has also been considered in para 58 of the impugned order.
Preventable omissions by the CI.
My lord, may I submit one thing, my lord? Apart from, my lord, the detection of, my lord, the investigation, or there is also detection for, my lord, compensation that has also not been paid. And my lord, there is the, my lord, the independent findings apart from the reliance of, my lord, the NHRC report, page 32, paragraph 61. If your lordship kindly see, the fault of the investigations has also been highlighted. Here, my lord, who are the accused?
Yes, yes.
Who are the accused in this, my lord, proceedings? Accused the SP, accused
no.
the MP, accused they.
May I
they-
place the case?
MP
Then may I place the
and, my
case?
lord, the local
Kindly
IC,
look
local
at
IC,
the complaint.
He was never made a party. in-
local IC.
Oh, it is chilo na.
No,
But I'm told, Milord, NHRC was not a party to this proceeding.
Not a party.
not a party.
That's what.
NHRC was the party.
But that's what
No, no, it's not there in the petition.
না না ওটা তো ভুল আছে পরে ওটা করা হয়েছে কারেকশন
Milord, kindly have a look to Milord. Milord, please have a look to Milord, paragraph 58 of the judgment, Milord. Milord, the appellant before.
But there is a finding that the provisions of the Arms Act.
yes
But I come to.
No, no, it's my domain, madam.
yes
CID has investigated on that score, madam. I can answer that question, madam.
But that also we have decided in one matter, in
Yes.
the election commission matter,
Right.
where the state refused to transfer the investigation to the central agency. We have held that though such incidents were reported in the FIR, those relevant sections of the Arms Act were not included.
But here it was.
Here,
It
yes.
was, my lord. Charge sheet was filed. Why Arms Act, what they are saying is, my lord,
So
the bullet
once the schedule offense is
there,
attracted,
is there.
then automatically.
yes,
it has
yes
to be-
automatic
But my lord, they have
that is there that is there
Central government. My lord, NIA has, central government has to give that sanction.
That we have issued a mandamus.
Hey, Darren, let me finish. Let me finish.
Suo can do it.
Yes.
Court can direct.
In
it.
fact,
The
court has
directed
directed in the other
but
matter,
yes yes
where just our former chief justice
My lord.
division bench also has done so. There are, in fact, there are 7 or 8 orders.
Yes, my lord.
I don't know whether senior is aware of,
No,
all
my
concerning the bomb blast,
Yes.
series of bomb blast prior to the panchayat elections.
My lord.
And in one matter also, we have
yes Ram matter
That has been affirmed by the Supreme Court. That was tested before the honorable.
My lord,
yes
this
Ram
amendment,
matter
2020. This incident of 2018.
Your lordship, that order
to
has been tested by the
2018.
honorable Supreme
Yes,
Court,
my
and
lord.
Supreme Court affirmed the order.
One minute,
still
one minute,
nothing,
Mr.
still nothing has progressed.
But a charge sheet has been filed.
No,
charge sheet has been filed against the, my lord, innocent villagers. Charge sheet has been filed against the innocent villagers. Till
How
date,
can
they cannot.
be innocent now, my lord.
We can hear the appeal probably next month. But in the meantime, you please implement the direction. It is not as if within 3 days they are going to complete the
Immediately after
investigation.
we root the.
Milord, please have a look to Milord, the appellant before the court is the state. Please have a look to paragraph 58 of the judgment. But the learned single judge says that the state is not required to be heard.
29.
Para 58 at page 29. The power of this court under Article 226 is wide enough to accept the report of NHRC as a preliminary inquiry finding. The grievance of the state that their police and administration have been indicted without being heard, if correct, may now be misplaced. The concerned police and the officials of the state administration would be heard in accordance with law in the event any formal prosecution is launched against them. There cannot therefore be any prejudice
To them as of now.
today, my lord, the state, my lord, under the constitution, my lord, has the right to carry on investigation. This is a state subject.
Not in a case where NIA scheduled offense is committed.
No, that is
Not at all.
case.
The schedule of
All right,
procedure
we have heard
automatically
the learned advocate general for the
Yeah,
appellant, Mr. Milan noted.
Chapter 4 of
Everybody,
the Act.
The question to be decided in this
আরে
appeal
শিডিউল অফিস তুমি
is
6
with
বছর
regard
নামনি
to
কেন?
the findings recorded
Why
by
did
the
you not take it
National
for 6
Human Rights
years?
Commission.
Why the appeal was not heard, mentioned
And
before
whether the findings so recorded
Convenient ওদের
in a report drawn by NHRC
অসুবিধা আমাকে তো রাখতে পারো তোমার
could have
সাথে।
been referred to and be made the basis for transfer of the investigation in the instant case to the
Hospital.
National Investigation Agency within bracket NIA. On a prima facie view, we opine that though the learned single bench in paragraph 47 has dealt with the jurisdiction of NHRC, the fact remains that the report drawn by NHRC continues to remain in force and has not been scrapped in the manner known to law. Therefore, we are of the prima facie view that there is no error in the order passed by the learned single bench in referring to such report to sustain its ultimate conclusion drawn in paragraph 73 of the impugned order. Since other legal questions, other legal issues have also been raised in this appeal by the at the instance of the state of West Bengal, we are inclined to entertain the appeal, but however, we are not inclined to grant any order of interim stay of the order and direction issued by the learned single bench. Accordingly, the appellants are directed to implement the order and direction issued by the learned single bench without loss of time, which such implementation, full stop. It goes without saying that such implementation to be done will be subject to the outcome of this appeal. The National Investigation Agency, by letter dated 25th May 2023, has addressed the Additional Director General, CID, Kolkata, requesting them to provide certified legible copies of several documents. This request appears to have not been complied with by the Additional Director General, CID, Kolkata, and therefore we direct that the documents sought for in the letter of the NIA dated 25/5/2023 be complied with within a week from date. The NIA shall proceed in terms of the directions issued by the learned single bench in paragraphs 73, 74, 75, 76, and 76. In paragraph 77 of the impugned order, the appellant state was directed to compensate the families of the victims, both killed and injured in the incident, within a time frame. The state shall ensure payment of compensation to the families of the victims, both injured and killed and injured, at the appropriate rates within 3 weeks from date. Full stop. List the appeal under the caption for directions on 14th May. No, on 15th May.
Malad, may I
Sir,
make
would
a
it-
small
would it be
request, Malad?
Lordship's pleasure?
A small request.
Would it
Malad,
be
there is
Lordship's
a
pleasure to
recap
record?
application pending on Friday. If that could be stayed, Malad.
Oh,
No
no,
activity.
No, you can give this order and the learned judge will accordingly modify.
I'm grateful. I'm
Lord,
grateful.
May I just make one prayer?
Yes.
Lord, your lordship had been pleased to record
the documents to be handed over.
Yes.
Kindly record that in terms of the requisition made by the NIA.
Already, my lord, there's only one issue here, my lord, just to clarify, my lord. What happens, my lord, once the charge sheet is filed, all the 207 papers and the charge sheets are all filed before the court. So, my lord, that has to be brought by
You
them.
have to pull it out. That last judgment you have got, are you carrying that Satar?
No, my lord, I cannot, sorry, my lord. Next day, my lord, I'll produce.
In fact, I had framed the questions.
Oh, in that, my lord.
In that matter.
Well, we'll just go
We
through
were
it.
hearing the matter, but then.
Well, we'll get through it. Well,
Next day, my lord, we'll have.
one of the questions forms a part of the judgment.
In fact, they went to the extent of arguing that it has become, once the report is drawn, it has become functus.
Functus officio, right?
No,
Functus
that can't be. That can't be, my lord.
The Ramavi matter also, a lot. Honorable court period, once the order, it was tested before the Supreme Court affirmed the order.
Next.
Grateful.
Grateful.
I'm grateful.
Serial number 7 and 8.
Well, only one thing, my lord, NHRC has not been in a party, my lord. He was originally party in the, my lord, original proceedings, my lord.
File an application.
My lord, because they have to make party, because this is their.
You can make a can application.
My lord.
I appear for the appellant in this matter, my lord. This is a matter relating to incentives, my lord.
But why you have denied the, as per the scheme, they are entitled for that.
No, as per the scheme, they were never entitled, my lord. You're subject to question, my lord, senior friend. If your lordship kindly sees, my lord. They had.
But what was your argument before the learned
My lord,
report?
we could not, my lord, because my name has been recorded in the order.
Yes.
In fact,
Capital letters, it is.
I was not. In fact, I was not there.
Well, during the course of hearing,
I was not there before the.
yes, absolutely correct. Mr. Siddiqui was not there. His junior was there. Then, my lord, the honorable single judge posed a question to his learned junior that by what time we will pay. I insisted there should be a payment by 3 months. Then, my lord, some bargaining continued. And then, my lord, it was settled that within certain.
Then how are we to test the correctness of this order, where you have not made any submissions regarding that they are not entitled to? That submission was never. So therefore, you should file a review. We can't test the correct. Here, the learned judge says that despite representations, nothing has been done. They are entitled to that. You please do it in installments or some direction. Yes.
Yes. We also did not.
In 3 installments.
We also did not pray for, my lord, completion of the pleadings for exchange of affidavits also.
Then you have to file a review, sir.
My lord,
We will grant you liberty, you file a review.
I'm grateful.
This intra-court appeal by the state is directed against the order dated 27/6/2023 in WPA 13775 of 2023. On going through the impugned order, we find that the learned writ court has taken note of, has recorded that the writ petitioner was entitled to refund of 90% of VAT and CST, which was paid by them. And despite several requests, the appellant authorities were not refunding the matter. Despite the scheme being enforced, which was notified by notification dated September 12, 2014. Therefore, the learned single bench had allowed the writ petition and directed disbursal of the entire amount in 3 installments. Before us, the state seeks to argue the matter on merits and contend that the respondent writ petitioner is not entitled for the refund of 90% of VAT and CST, which was paid by them. If that be the case, the appellant should have agitated such an issue before the learned writ court, and we cannot permit the appellants to do so in this appeal for the first time. if according to the appellants, the order impugned suffers from errors apparent on the face of the order, then it is up to them to seek for a review of the order and judgment and order, and filing an appeal is not the appropriate remedy. Therefore, we are not inclined to entertain this appeal. However, it will be well open to the appellants to seek for review of the impugned judgment and order if so advised.
Great. 7 and 8, my lord, will be
নাহলে তো আবার সার্টিফিকেট কপি অ্যাপ্লাই করতে হবে অন্য কপি হ্যাঁ দিয়ে দিচ্ছ বলে দাও হয়ে যাবে তুমি অ্যাপ্লাই করবে স্যার করবি আবার বুঝতে পারছি তো
limitation বাঁচাবে limitation তো already leave granted
দেখো স্যার
Sign. But may I?
Yes.
May I be allowed to take back the certified copy of the?
Department is directed to return the certified copy of the impugned judgment and order after retaining a photostat copy. Return so to the learned advocate for the appeal. Next.
But 7 and 8 are covered by
Common order. 7 and 8. 9.
Serial number 9.
Madrasa education.
Affidavit of service.
I have an application can 3 of 2023 for addition of party, my lord. I am a teacher in charge of the school, my lord. My lord, the it is regarding the management and the affairs of the school. I have not been made a party. If I can be added as a party to the petition.
And what is the direction, sir?
Actually, I am representing the West Bengal Board of Madrasa Education. So, one managing committee which tenure has lapsed since the last 13 years. They are into the helm of the affair by some means or the other. Thereafter, they had taken an order by way of suppression and not impleading me as a party, nor impleading the teacher in charge as a party. They purportedly made some other person to be a teacher in charge, Maidul Khan, to be the teacher in charge, and taken an order without impleading me as a party. Because of that, I'm over here.
No.
And they are debarring me. They are debarring the teacher in charge. They are debarring any of the officials from entering into the school premises.
But then the writ petition was filed by the managing committee.
It was filed by the managing committee.
And they claimed that the private respondent is a teacher in charge of Kontai, another madrasa.
That was the wrong.
And he is wrongfully entering that
particular. I am the teacher. I'm rightfully the teacher in charge. It has been suppressed in the writ petition that I am the teacher in charge. Somebody else alleged that he is the teacher in charge.
You could have filed a third-party review before the learned writ court, saying that I should have been heard. See, these are the documents in my possession.
I just have an order.
I went before the learned judge, but the learned judge on that particular point of time never allowed me to implead me as a party. I was present in the court.
You can file.
I had pleaded. I'm for the West Bengal Board of Madrasa
But
Education.
in this, you have taken leave to file appeal?
Lordship, I have taken leave.
That application is there?
Yeah, Lordship. And all the copies have been served on the last occasion. He was the managing committee.
And who appears for the managing committee?
Managing committee, Mr. Shomen Datta normally appears for the managing committee of the school. The manager, there has been an administrator appointed in the school, and by the board, my lord,
Yes,
upon orders of.
On the last occasion, Mr. Soman Datta appeared.
He represented.
My lord.
Where is
Not today, engaged in another.
This is the Lord just
Probably the 7th or the 8th time, my lord, adjournments have been prayed by the writ petitioner respondent.
No. On 2 occasions, the appeal was defective. Therefore, we adjourned.
Lordship.
And the last occasion on 23rd February, you had filed Can 4 of 2024.
But Can 3, man.
Lordship, Can 4, I filed.
You had filed.
Can 3 is my application.
And you are directed to serve copy of Can.
Lordship, we have already filed. We have already served.
Have you received copy of Can 4?
Lordship, an endorsement has been, I've given it personally.
All right, we'll say not today because he's not today. Next.
Serial number 10. Not today, sir.
Grateful.
May I, my lord, before my lord, going into the impugned order, my lord, the
But
facts is, my lord,
unfortunately, what happened is this, my lord, ELAR has engaged myself and the senior standing counsel, but no brief they have supplied, my lord. Only the engagement letter I have received, my
today, my
lord.
lord, my prayer is
If
to
my
consider-
learned friends supply me a copy of the brief, my lord.
Then
consider representation only. Only consider.
No, if
I am a writ petitioner.
correct, sir, if the scheme does not provide for compassionate appointment,
This is not a compassionate appointment.
Ah.
No, I am.
the learned
my lord,
judge has recorded.
that is my lord, that is why, my lord, I am before your lordship.
Ah.
This is not, my lord, this is a change brief, my lord. I am before your lordship because of this is not, but I am the writ petitioner. I am alive, my lord. But my lord, license is in my name. But I could not run because of medical reasons. So I want my son to be run this, my lord, my stamp vendor.
But before that, there is a delay of 1,460 days.
I know, my lord, because my lord, my lord,
Your son cannot succeed you because this is a license.
I know.
So license is not transferable. Your son can make a fresh application under the rules. If a fresh application they are entertaining, because now stamp vendors have virtually become redundant after the
Because of my lord.
e-stamping.
And these are, my lord, from the
Now what they have done, they are now having a laptop, and once you make a GPM, you ask them,
griefs they obtain the, my lord, this,
and they will generate it. They will sit outside and they'll upload the e-stamp and give you a printout. And for that, they'll have a service charge.
These stamp vendors are from, my lord, the subdivisional courts and, my lord, from the villages. My lord.
Even there, they have.
Kindly give us a liberty to make an, my lord, such an application, and, my lord, and let them, my lord,
there is a
decide.
delay of 1,460 days in filing the appeal. We have perused the affidavit filed in support of the condoned delay application, and we find there is absolutely no reason for the inordinate delay in filing the appeal. Therefore, we are not inclined to condone the delay. The learned advocate for the appellant submitted that the appellant the facts have gone down wrongly before the learned writ court, since the appellant is not seeking for any compassionate appointment, but the appellant's request to the department was to permit his son to operate the stamp vendor's license granted to him by substituting his name in the place of the appellant, since the appellant is unwell. Under the relevant rules, there is no provision for such substitution, and if at all, the appellant's son is desirous of securing a license, it will be open to the said person to apply for the license as per the extant rules. The above observation.
One visit before lordship, my lord. But they will never, my lord, they will never, my lord. They will never. So, my lord, kindly specify any time, my lord. Kindly, my lord.
No.
That is the only thing, my lord, I beseech your lordship.
Sorry, sir. Next.
Serial number 11.
I am for the appellant.
This matter, I am praying for a day's accommodation, my lord.
You are for the appellant.
No,
So
my
I am
lord,
for
I am
the
appealing for the respondent.
There was a direction on the last occasion that Mr. Mojumdar will make
Mr.
argument
Mojumdar, Mr. Obhotos
respect
Mojumdar
of
is appealing for the
maintainability of the
respondent.
writ petition, and you will realize some Supreme Court decision. That was the order recorded. A point cropped out whether writ petition is maintainable for the purpose of recovery of money. And whether the writ petition was filed after 5 years. Item 22 to 25 out of the same order. So let those be taken.
Item 11, 22 to 25.
25.
Yes.
Not today.
Great.
Diploma.
Serial number 12.
Admission is also.
It's a very short point, not the admitted bills, which has even been prepared by the Vidhannagar municipality, but they are releasing the amount. I have to sustain on this. The last occasion, my husband sought time to take instruction on that. I can hand over a chart of the admitted bill. Let them release the amount at a certain point of time.
But in a writ petition, unless it is admitted, we cannot issue a direction. If suppose they say there is a breach of contract.
Nothing. If any such allegation, those amounts may be segregated. There is no such allegation. Admittedly, I just show your lordship that kindly sees the bills which they have prepared. Page 98 onwards. Bills have in fact been prepared by the department, certifying that I have completed this work.
But paragraph,
any controversy that I would definitely not press upon.
But the learned judge in paragraph 13.
Unfortunately, this was a mismatch because of typographical error in the pleading, which was not corrected, unfortunately.
No, in para 13,
yes,
the learned judge records that the claims are disputed squarely by the respondent. Calculation and detailed evidence-taking procedure is required to be gone into before deciding conclusively. All that we can do is we can ask them to decide on the admitted amount.
Yes, that's what I'm asking for.
And they can tell which of the
is that disputed and why.
On dispute, you file a civil
suit. Yes.
You decide that
admitted amounts that are not disputed should be released.
If X is the admitted amount or which he is entitled to, you release that. So far as the remaining amount, you pass an order saying that for such reasons.
Yes, yes.
Milord, in this matter, Milord, what they did, Milord, they have clubbed several claims, including claims which are arising in 2012. They have
time barred, is it?
Time barred, non-time barred, everything brought together. Now, Milord, the difficulty is that Milord, this is a simpliciter money claim. Milord, it is not a question of going back, as my learned senior is making submission, Milord, of taking instructions and coming back. Milord, in this matter, we have filed affidavit disputing the claim of the petitioner. Your lordships will find my affidavit from page 150 onwards. It was extensively placed before the Honorable Single Judge. And, Milord, if your lordship kindly, for example, kindly takes, Milord, paragraph 8 of that affidavit. Milord, I am only, as an example, I am placing a few paragraphs, page 152, paragraph 8. That it is disputed with respect to the amount claimed by the petitioner by means of the writ petition is praying for release of due amount to the tune of 65 lakhs so and so, which is not true as per the records of the Vidhannagar Municipal Corporation. Now, paragraph 10. That as claimed by the petitioner for a work executed in 2012, no work order or work completion certificate is attached with the writ petition, but the petitioners are claiming an amount of rupees 1,20,119 for purported work done in the year 2012. Such claim is thus horribly barred by limitation. Then the petitioner has failed to apprise this court that they have already received part payment from BMC authorities to the tune of 7,40,000. So and so. Then Malad kindly turns over Malad to paragraph 15 page, Malad internal page 5, that is 154 of the stay application. First paragraph, last sentence. I say that an ad interim payment of 5 lakhs has already been made by the Vidhannagar Municipal Corporation. Now, Malad, what they have done, Malad, they have jumbled up everything, put it in one basket, and made a writ petition saying that the BMC owes so and so. Malad, everywhere we have disputed, Malad, your lordship, if your lordship kindly takes, for example, one paragraph of the writ petition. The writ petition is starting at page 76. Paragraph 21 of the writ petition at page 88 of your lordship's brief. Kindly takes, Malad. Paragraph 21. This was also placed, Malad.
Oh, without paying, this is fixed court fee. If you had gone to the suit, then
no.
Malad, here, if you
not that.
In a writ
but I have
petition
94
is
supplemented.
What
94?
On that basis, I'm asking. I have not.
I think that these are unnecessary argument. Kindly
Malad, these things.
Let me finish.
So according to you, they have clubbed all the various works.
But kindly see page 88 onwards, 88, 89 and 90. Malad, different things, different contracts between the parties of different periods, different work done. And what they have done, they have also brought in claims of 2012, maybe 1,20,000.
but they knew that this is barred by limitation. So they have jumbled up everything together and tried to make out a case that these are all admitted, and we have already taken instruction. We have filed our affidavit. It is on record. Our dispute with regard to these amounts are on record. And the Honorable Single Judge records that I have asked the petitioner about certain claims. They have not been able to satisfy me about the document. And that is why the need of this document outside the appeal is required to satisfy today. And these were all gone into. And there's another problem. This is purely contractual in nature. What the Honorable Supreme Court says, if your lordship kindly considers only one judgment, it has said, I have compiled 4, but kindly take the first one only. That is 1994 supplementary 2 Supreme Court cases 466. That is the first judgment in the compilation. But why this should not be allowed? Kindly take paragraph 2. It is only one relevant paragraph in the judgment, that the respondent has money claim against the appellant. Instead of moving the appropriate court in a suit, they approached the Calcutta High Court under Article 226 of the Constitution. The writ petition attracted a counter from the appellant, who raised a counter claim. Without adverting to the counter claim, the High Court went on to grant relief to the payment of certain sums to the writ petitioner on the basis of certain suggested admissions made by the appellant. The High Court then followed 2 separate courses, inasmuch as relegating the appellant to the remedy of suit insofar as the counterclaim is concerned, and ordering payment against the appellant insofar as the admissions went. This twin course appears to us to have been wholly wrong. It does not appeal to us as to why a party has to go piecemeal in a civil court, though it is appreciable that when a claim is admitted, a decree may be permissible to be passed under the CPC. But that too has to happen in a suit before an appropriate court of law. We thus are persuaded to straighten out things which have gone awry, if not for anything else, at least for the sake of procedural and judicial discipline. Therefore, we allow this appeal and so and so. So, in this contractual dispute, I may have a counterclaim against them. In my file, by filing an affidavit in opposition, I cannot raise that counterclaim before your lordship by way of a mandamus against a private party. This is what the Honorable Supreme Court said, that if I may have a counterclaim, so my remedy remains in the civil court and their remedy becomes in the 226. This twin course cannot be adopted, my lord. If they say that there is an admitted amount, they can pray for a decree upon admission, my lord.
Yes.
They can. That course is open to them. So, my lord, this course they cannot take, my lord.
Yes, sir.
Law, as he stated, it has become an outdated law. I will come to that. Kindly turn to the documents, page 98. Is it disputed that this is prepared by the executive engineer, Bidhannagar municipality, not by me? They have given this certificate. I have worked this, and this is total amount. And then below page 99.
100.
Then page 100. These are all admitted, issued by them. So that he is drawing below an analogy of 2012 due payment. If you say this is barred by limitation, you leave that aside. But for that, you cannot deny the current claim, which is prepared by you. The bill is prepared by you.
But how to decide that in a writ petition?
No, they have not disputed these bills.
No, but in the affidavit.
In the affidavit, kindly see the nature of affidavit. Dispute. Dispute what? Mere dispute would not do. If I may produce, this is the Bidhannagar Municipal Corporation. They have raised the bill.
They have said the payments have been.
These are not at all raised by my client.
No, they say the payments have been made to the petitioners on the basis of work orders issued on timely basis.
Yes,
but the petitioners
I am asking that.
With false, fabricated and distorted numerical figures, the veracity of which is yet to be ascertained.
Then, unless they ascertain, they say that they dispute. There is no question when the counterclaim.
Then they
These
say
are the work order issued by them.
the description of the work order number and tender number does not match with the description of the job. Completion certificate so attached does not match with the amount due or the amount claimed by the petitioners. Ulterior motive not annex the actual work order.
But the work order is with them. But if these bills similar, they say this is disputed, but which are prepared by them.
It is better you file a suit, sir.
No, I don't have to file suit. Let them dispute each bill, saying that this is dispute because of this.
That is
but the public sector, nothing. I mean, the municipal corporation. The latest judgment of the Supreme Court is completely contrary. that you cannot get somebody your job done and then do not pay. Well, let them not specifically say so, but the annexures given the which are they disputing. Then of course I will be out of court. Do they dispute that the executive engineer has prepared this bill after being satisfied with my job? 98, 99 onwards up to page 125. Look, this is unfair. This has specifically now been held by the Supreme Court that even in contractual matter, the public authority cannot be unfair. And the judgment side is a completely different thing, a different factual context. And you can now come to page 114.
Now, as per the direction of the division bench, in page 169, there was a direction to consider the representation.
169.
169.
Yes. Nothing has been done. It's a matter.
No, someone else's matter.
Someone else. This is not.
They cited it as a precedent in the writ petition.
This is someone else.
Probably that exercise can be directed to be done.
Yes.
They can pass a recent.
Let them state categorically that we are disputing these bills for X reason.
We can't issue a mandamus. We can only say that if you make a comprehensive representation, clearly setting out what are the claims, duly supported by copies of work orders, completion certificate.
That is here.
No. You make a comprehensive representation and then let them consider that. To that extent, we can issue it.
Yes, but not with a mere considering saying that we do not accept it. But they have to
no. That liberty has to be given to them.
No.
If suppose they take a stand that the work has not been fully complete, therefore you are not entitled to this amount. Whatever has been, your entitlement has already been paid. They are entitled to. We can't direct them to decide the matter in a particular manner.
No. What I'm not able to communicate to your lordship. The bills which I have prepared is on the basis of the certificate given by the executive engineer. If they do not dispute it, let them pay. If they dispute it, give me the reason so that I can challenge.
All right. This intra-court appeal by the writ petitioner is directed against the dismissal of the writ petition by the impugned order dated 15/12/2023, wherein the appellant prayed for payment of the bills raised by the appellant in respect of various works done for the respondent municipal corporation. As rightly held by the learned single bench, in a writ petition under Article 226 of the Constitution of India, court cannot examine disputed questions of fact nor issue a direction for settlement of money claims. In this regard, useful reference in this regard, it is beneficial to refer to the decision of the Honorable Supreme Court in Eastern Coalfields Limited versus Ravi Udyog and others, 1994 Supplementary 2 ACC 466, and the decision in Bareilly Development Authority versus Agrawal 1989 2 ACC 116. The learned senior advocate appearing for the appellant submitted that the claims submitted by the appellant was duly supported by completion certificate issued by the executive engineer of the respondent municipal corporation, and the respondent cannot deny payment to the appellant. In the writ petition, an affidavit in opposition had been filed denying and disputing the claims made by the appellant, apart from stating that one of the claims made is for a work purported to have been done in the year 2012, and such a claim is hopelessly barred by limitation. Thus, the ultimate conclusion arrived at by the learned single bench cannot be faulted. However, we are conscious of the fact that till date, the appellant has not been informed as to which of the claims made by them are admissible or not admissible. Yes. And if they are not admissible, the reason as to why they are not admissible. Yes. Therefore, to that extent, we are inclined to issue appropriate direction to the respondent municipal corporation, subject to the condition that the appellant makes a comprehensive representation to the said effect. In the result, while declining to interfere with the findings rendered by the learned single bench in the impugned order and affirming the same, we grant liberty to the appellant to submit a comprehensive representation to the respondent municipal corporation, clearly setting out their claims and enclosing all relevant documents such as work orders, copies of the bills, completion certificate, etc. And on receipt of the representation, the respondent municipal corporation shall consider the same and pass a reasoned order on merits in accordance with law and communicate the same to the appellant within a period of 4 weeks from the date on which the representation is submitted. Next.
Serial number 13.
Lord, I am for the petitioner, Lordship. I, Lord, come here, my Lord, before your Lordship, my Lord, against the order. Order was passed, my Lord, by Honorable Single Bench, my Lord, without going to the merit of the case, my Lord. What our case, my Lord, had not
But
been.
writ petition, how to quash a charge sheet, sir?
My Lord, one thing I pray before your Lordship, one thing.
Seek for discharge. There are a lot of remedies available under CRP.
My Lord,
Several decisions we have rendered.
my Lord, one thing I kind of, my Lord, 1 minute I shall take, my Lord, only this. My Lord, only this, my Lord, this my client cannot be suffered, my Lord, by the police authority. Police authority regularly, my Lord, raiding the house of the petitioner and also the maternal house and the side houses also regularly coming, my Lord. So the petitioner, there is nothing, any fault on the part of the petitioner. Lordship, there is two rival groups.
No, petitioner is a doctor.
No.
Oh, then?
He is a temporary service holder, my temporary post, my Lord. Under the video, my Lord, he is under the video. The petitioner, my Lord, petitioner father is a one group of the political party and respondent number 5 is another group of political party, my Lord. There is the various, my Lord, friction with the politics, my Lord, in the said villages, my Lord. But the petitioner, the respondent.
The scope of the writ petition.
No, I am
coming
coming.
about anything.
You stop it. Kindly, তুমি পরে বলো না, stop and.
Well, only one thing, in that event, there is no section 5 application is there.
The petitioner was a contractual employee in the block development office.
My Lord.
And what did he do?
He is now, my Lord, he is now out of sight, out of place due to afraid of police authority, my Lord. Police authority. The Lordship kindly see the respond number 6. Respond number 6 is the husband of the victim lady, my Lord.
But the allegation is that the petitioner administered some medicine.
No, it is a concocted, my Lord. To only the only Lordship, only
petitioner. Sorry, sir. By the writ petitioner is directed against
Lordship
the
kindly
13/2/2023, by which the writ petition filed by the appellant to quash the FIR and the charge sheet was dismissed.
It is absolutely, my Lord. In terms of the
refusing to exercise discretion, refusing exercise jurisdiction under Article 226 of the Constitution.
I get 226, my Lord. So many judgments are here, my Lord.
Quash an FIR and a charge sheet. Therefore, we find no grounds to.
And a judgment are here, my Lord.
Yes.
226, my Lord, judgment, my Lord. Lordship, kindly see this.
Lordship, please to dismiss the same.
Serial number 14.
Lordship, one thing I pray, Lordship, my Lord. I will.
You can't administer medicine to them.
My Lord, my Lord, one thing I pray.
Detected after the.
One thing, my Lord, protection of. I will face the trial, my Lord. Trial.
You file a petition for.
Otherwise, I will be harassed, my Lord, by the police authority.
Next.
Serial number 14.
Lord, I appear for the appellant.
Lord, on behalf of the respondent, my Lord, I beg to appear. Lord, I'm being led by Mr. Probal Mukherjee. He is, my Lord, on his legs, pray for a short Passover, my lord.
Lord, only thing is, Lord, there is a contempt, Lord, application which is due to appear, Lord, on the Friday, Lord, the coming Friday.
Friday.
5th.
You seek for adjournment of the contempt.
Yes, Lord, that they can do, Lord.
My lord, on the last occasion, it was adjourned probably.
Yes, because, Lord,
On the ground of
But
this
the
appeal
learned
being pending.
advocates for the parties. The learned advocate appearing for the respondent in petition seeks for an adjournment. List the matter next Wednesday. In the meantime, the respondent shall not press the contempt application, which is stated to be listed before the learned court on 5th. On 5th. Next,
Serial number 15.
But 15 happening for the appellant.
For the respondent number 1 and 2, Lordship, in this matter, I am seeking for not this week, Your Lordship. The parties seek to change the previous advocate on record and the counsel, Your Lordship. Kindly can't be noticed this week in this matter.
Well, a writ petition, but it is a private contract between the appellant and the respondent number 1. There is an arbitration clause. The respondent number 1 being the writ petitioner, violated several clauses of the agreement, in spite of their arbitration agreement, learned judge not allowed the writ petitions and quashed the termination notice. And this appeal is of 2021. If your lordship kindly goes through the earlier orders, not every occasion they have come and paid for adjournment.
Your Lordship, there is no urgency in this matter. Lordship,
We are suffering. We are not getting our payments. They are absolutely violating the payment clause, that I
ago when they have not appeared in this matter.
So, once he's paying for adjournment, at the same time, he's not raising his voice in this way, If your lordship kindly takes up the impugned order,
I am not raising my voice. Apprising the court as you are apprising the court.
All right, 1 week.
Lordship kindly records an order, that
Yes.
and my lord will kindly direct the matter to
It is
retain its
submitted by
position.
the learned advocate for the respondent that there is likelihood of the counsel being changed, and therefore adjournment is sought for. By way of last chance, list the matter next week.
Let it retain its position, my lord.
In the same position.
Same, deeply obliged.
Next.
Serial number 16.
I'm appearing for the appellant.
In this matter,
My lord, on the last,
this matter was fixed today for
we took
hearing.
an adjournment on Monday, my
My
lord.
Lord, I am the one who has sought for an adjournment, but unfortunately, under most compelling circumstances, I am being forced to seek a further adjournment for this day.
My lord, this is the 5th adjournment by
I-
my learned friend before my lord.
Then.
My Lord,
We'll have to ask her to re-argue the entire matter.
My Lord,
My lord, I'm at my lord's mercy, my lord. We are coming every day and they speak an
My Lord,
adjournment.
today itself, Mr. Shoigat Raichuri, who is appearing on behalf of the respondent numbers 5 to 9, in the BCCL, who is the main answering respondent, I was told that his father's blood pressure spiked up to 190 by 120. He's a serious patient of an octogenarian person who is seriously suffering from neurogenic disorders. My Lord, it a kindly to my.
No, we'll take your word. Of course, your friend also.
My Lord, I just bow down to the gracious good nature of my learned friend as well as your lordship, my Lord. Because under most compelling circumstances, otherwise.
Because this is a
I understand,
continuing matter.
My lord, I had submitted for half an hour. I had indicated that I would take 20 more minutes to place what is there, stand in the affidavit in opposition. My lords had wanted
You
to
have
know.
to give us a recap.
My lord, I will do that, my lord. I'll just.
But any day subject to your lordship's convenience, I'll inform my learned senior about this transfer.
It was fixed today as per his convenience,
my lord.
But
then some
there's something
emergency
has
has come.
happened which we.
It kindly my lord to passport.
No. At the request of the learned advocate for the contesting respondent, list the matter next Wednesday in the same position.
My lord, I'm deeply aware.
Next.
Also thankful to my learned friend also for this for her kind
Serial
consideration.
number
Can we pray
17.
for Monday, my lord, or next Wednesday?
Next Wednesday.
My lord.
Serial number 17.
17, my lord, I have to give
My lord, it has been recorded that it's been adjourned at the request of.
Yes, my lord.
Contesting response.
My lord, my lord.
Grateful, my lord.
Yes.
Mr. Banerjee is to reply, my lord.
I have to give my reply, my lord. This is that Apollo matter, my lord, will recall, my lord, where my lord, the challenge, my lord, was to, my lord, the clinical establishment, my lord, regulatory commission, which is, my lord, a statutory body, my lord, set up under, my lord, the West Bengal Clinical, my lord, Establishments Act, my lord, passing, my lord, advisories, fixing, my lord, rates with regard to, my lord, private hospitals, rates of, my lord, treatment as well as, my lord, as to how much, my lord, should be, my lord, charged, my lord, for beds and, my lord, that was the challenge. My lord, we were successful. the advices were quashed, and it was said that they didn't have the jurisdiction to have this. The regulatory commission itself has preferred an appeal now. So one of the points I urged, saying that the West Bengal Regulatory Commission could not have preferred the appeal firstly. And secondly, I also want to show that it is still without jurisdiction. My learned friend, the learned advocate general has relied on cases. First, he says that since it's a administrative body, therefore it can prefer an appeal. His argument was that because I had shown cases where quasi-judicial authorities cannot maintain an appeal because it's really an appeal from their own orders, and his point was that a body constituted by a statute and issuing orders can appeal. Here I'm joining issue. So my first submission on question of maintainability is that this clinical establishment, clinical authority, clinical commission passes advisories and also deals with violation of those orders and imposes penalties. So in that sense, it is exercising a quasi-judicial authority as well, and it is really sitting in appeal. In that sense, when they file the appeal, because implementation of those whatever they've issued is also with them. Well, it's not a purely a body which is only issuing orders. If takes the act once, the West Bengal Clinical Establishments Registration Regulation and Transparency Act.
Yes.
First, kindly come to section 36 Constitution. The state government shall constitute a West Bengal Clinical Establishment Regulatory Commission to exercise the powers and perform the functions conferred on the commission under this act for the purpose of regulation and supervision of the functioning activities of clinical establishments licensed under this act, of ensuring accountability and transparency in dealing with patients by clinical establishments, in providing patient care service, to advise the government on measures to be adopted for enhancing and augmenting the performance of clinical establishments in the state. Then shall consist of, West Bengal Clinical Regulatory Commission shall consist of chairperson appointed by state, vice chairman, members. Then terms are not then 38. The commission shall then will kindly come to 4, which is what they rely upon. Subsection 4, make regulations with regard to fixing of rates. Again, not necessarily fixing of rates. Make regulations with regard to fixing of rates or charges for indoor patient department, outdoor patient department treatment, including diagnostic, and then can you see make
3 also has the power to adjudicate the complaints.
And also 338(1)(3). That is examine and consider complaints. And last portion of that provided further that the commission for the purpose of adjudicating disputes and appeal. So also adjudicates disputes arising out of the complaints.
Yes.
So 38(3), 38(1)(3) will show that it also has adjudication powers. 38(4) requires make regulations with regard to fixing of rates. Now regulations, it will kindly come to section 52. 52. Commission may, sorry,
Yes.
Commission may, with the previous approval of the state government, by notification make regulation not inconsistent with this act and the rules made thereunder to provide for all matters, and the rules made thereunder to provide for all matters for which provision is necessary or expedient for the purpose of giving effect to the provision of that patient can establish. So, the scheme of act shows, first, it is constituted, under this act as a body, which also has, adjugatory powers. So, that is, established by 38(1)(3), as well as, even another section, 38(1)(8). Here, appeals arising from orders and decisions passed by the adjudicating authority in the districts. And then, section 52 requires that, the regulation, if framed, firstly, cannot be inconsistent with the act or the rules, and has to be with the previous approval of the state government. And in the rules, one rule is very important, which had noticed in the earlier division bench order, which had passed, saying that you really don't have the powers also. I'll show that. Rule 19.
Which are the rules? 2017 rules, is it?
Yes, 2017 rules. Perhaps if it's the same, it starts.
That is registration regulation.
Yes, West Bengal Clinical Establishment Registration Regulation Transmitted Rules 2017.
113 page. Yes. Which rules?
Rule 19. Rule 19, clinical establishment shall have a right.
Yes.
Clinical establishment shall have a right to impose different rates of user charges and consideration. So the clinical establishment shall have a right to impose different rates of user charge in consideration of the provision of different kinds of services to be rendered by it, subject to definition rate charge of user charges, describing item charges for all service along with the concession, which shall be published in information brochure and shall be published. So the rules gives the power to clinical establishments, and this had noticed in the earlier division bench order.
Yes.
Now, kindly, I want to first show the and then deal with his cases. This is the earlier order which was passed, the judgment of 12th July 2023. Perhaps has given copies of this Bhaskaranando Haldar versus the state of West Bengal. We have you were there. No, the division bench of our courts.
Yes, we have got it.
Malad has the knowledge. Yes. Right. In the public interest litigation, the petitioner seeks for issuance of writ of mandamus directing respondent numbers 2 and 3, namely West Bengal Clinical Establishment Regulatory Commission to comply with the provisions of 38(1)(I), II, and 4 of the West Bengal Clinical Establishment Registration Regulation transfer within a specified time. Learned advocates for the petitioner would strenuously contend the terms of 38(1)(I), 4, 2 and 4, the West Bengal Clinical Establishment Regulatory Commission, hereinafter referred to as the Commission, has the power to monitor the functioning of clinical establishments, regulate and supervise functions as prescribed, and also make regulations with regard to fixing of rates or charges for indoor patient department, outdoor patient department, treatment, including diagnosis, also to ensure compliance with fixed rates charged by clinical. Therefore, admit necessary direction. Then, we have heard the submission, learned advocate general appearing for the state. Then the first hurdle of the petitioner has to cross is to satisfy the course maintainability of the press software and the petition, seeks a direction. Kindly similar, as noted above, petitioner seeks for a direction to comply with the 3 of the clauses under 38(1), 2, and 4 of the West Bengal Clinical Establishments Act. Undoubtedly, Section 38(1) enumerates the powers and functions of the Commission. One such power is to frame regulations for the purpose of fixing of rates or charges for indoor departments and outdoor patients department treatment, including diagnostic, and also to ensure compliance with fixed rates and charges by clinical establishments. However, such regulations cannot be inconsistent with the provisions of the Act or the rules framed thereunder in the light of specific embargo under Section 52 of the Act. Said provisions state that the Commission may, with the previous approval of the state government, by notification make regulations not inconsistent with this Act and the rules made thereunder provide for all matters for which provision is necessary or expedient for the purpose of giving effect to the provisions of this Act and patient care at the clinical establishment. In exercise of powers conferred under Section 59 of the 2017 Act, the state of West Bengal has framed the West Bengal Clinical Establishments Registration Regulations Transfer Rules 2017, and Malad, can you see that Rule 19 of the said rules would be relevant? This is what I showed, Malad. Rule 19(1) states that the clinical establishment shall have the right to impose different rates of user charges in consideration of the provision of different kinds of services to be rendered by it, subject to declaration of a rate charge of user. Charges describing item-wise charge for all services along with concession, if any, which shall be published in the information brochure, shall be displayed part of the mandatory display under Rule 22. This is a rule having been brought into place which empowers the clinical establishments to impose different rates of user charges. A rate of mandamus as sought for by the writ petitioner cannot be granted. That apart, as rightly contended by the learned Advocate General, prayer sought for in the writ petition is premature, since it appears that as on date the regulation yet to come into force or is in the nascent stage of being prepared and approved. Then more importantly, the question would be as to whether the court in exercise of powers under Article 226 of Constitution, well, that is the issue with regard to direction. Then will kindly come to page 5.
Primacy of the rules over regulators.
Well, in next page, page 5, in light of the clear legal pronouncement, the prayer sought for cannot be acceded to, as the learned senior advocate appearing for the private respondent places reliance on the decision of Honorable Supreme Court, case of Government of Andhra Pradesh, wherein Honorable Supreme Court pointed out hierarchy, Constitution of India, statutory law, which may be either law made by Parliament or by the state legislature, delegated regulations, which may in the form of rules made under the statute, regulations made in statute, purely executive orders not made under any statute. That this decision has been designed to show that the regulation any framed in exercise of powers conferred under regulation section 38(1) of the Act is subordinate to a rule which has been framed in exercise of powers conferred under the Act. Thus, for all the reasons, prayers for cannot be granted. Now, Malad, this judgment, Malad, is squarely on this issue with regard to, because what has happened, Malad, the clinical establishment is, Malad, issuing advisories fixing rates.
Okay, the clinical commission.
Advisement. The clinical commission, they are fixing, issuing advisories, fixing rates for private hospitals. Malad, I'll just show one of them, Malad, if Malad wants to have a
146
Malad, of the appeal. Malad, kindly come to page, just one of them, Malad, there are several like that, just one of them, page 146. Please, Malad, whereas West Bengal Clinical Establishment Registrations and such under Section 38, whereas it has been under Constitutional Commission to give a cap to rates for various common radiological, pathological tests to put a check, whereas the Commission formed 2 expert committee of eminent medical professions. I don't know, Malad, how, Malad, they. Where is the power? Committees of eminent medical professions to deliberate on the issue and suggest reasonable rates for radiological and pathological tests, wherein the following rates were suggested by expert committees formed of the Commission, whereas the Commission approved the following radiological pathological rates after due deliberation. And Malad, all these rates are fixed.
Advisory अलग देखिए. Advisory 14
And then Malad sees next page 148, and where it is now decided by the Commission to give a formal effect to the above radiological and pathological rates, this capping will apply to the following CAs. Then this order will, then Malad, after A and B, order will take force with immediate effect.
Regulation without to fixing rates.
And then also Malad one page 119 advisory 14. Paragraph
Page 119.
119, Malad, paragraph 2. Commission thus feels, and Malad issued by the secretary says, Commission thus feels that clinical establishment must give at least 10% discount to all medicines and 20% discount case of supplied directly by them through the pharmacies. And Malad Arshad, the secretary, West Bengal Clinical Establishment Regulatory Commission. Now, Malad, the justification Malad sought to be given, because this is not even Malad the state issuing, it's Malad the statutory Malad, a body Malad which has been constituted under the Regulatory Commission Act. They're issuing advisories to say how this is how rates will be for private hospitals. Now, Malad, my first submission was Malad before the Malad Nanit Singhal Judge saying that it is without jurisdiction because anyway 38(1)(4) requires a regulation to be framed. In the matter of that, really, Malad, the regulation is also Malad because it can't also be inconsistent with Rule 19. So the regulation has to be framed with regard to how you should really charge. That's the language of Malad 38(1)(4). To that, Malad, the answer of Malad, the Regulatory Commission was that Malad, in the absence of regulations, and they relied on certain decisions, including before my lord, 2 decisions, they can really issue these advisories. Sorry. Because there's a gap. But I'll show, Malad, I'm sorry, Malad, with great respect, Malad, to the Commission, Malad, those are all cases relating, Malad, to service conditions. In fact, Malad, I'll show one of the judgments, Malad, of Malad T. Kaji, which in fact, Malad, distinguishes between an administrative, purely administrative decision to regulate service conditions and where, Malad, this kind of directions are issued affecting fundamental rights of, Malad, a petitioner.
That is that 77 Supreme Court.
77, Malad, is relied upon by them. In fact, Malad, 77, if Malad looks at
Para 31 was related.
Yes, in fact, Malad, kindly look at that's their judgment, paragraph 31. I don't know, Malad, even this doesn't support them really. And here also, Malad, the state was issuing it. Kindly see, second question is whether the requirement of 10 years experience was a statutory rule. The High Court held that the requirement of 10 years experience not a statutory rule. Counsel for the respondents contended that the requirement of 10 years experience is statutory because the letter dated January 16, 1950 is by the Government of India. And the Government of India has authority to frame rules, and one of the letters dated July 21, 1950 referred to it as a formal rule. The contention is erroneous because there is a distinction between statutory orders and administrative instructions of the government. This court has held in the absence of statutory rules, executive orders administration may be made. This is what they relied upon. And they also relied upon, since we are 2022, one Supreme Court cases 322.
Yes. Punjab State.
Yes, my lord. Paragraph, my lord, 15.
of the paragraph. They are not considered.
My lord, in fact, I'm sorry, my lord, may I just show paragraph 2 first?
Yes.
To show, my lord, what was really, my lord, the issue. The PSCB, in order to settle the issue of stagnation in various cadres of regular employees, had passed an office order on 19 July 1989, introducing a scheme to allow a time-bound benefit of the higher scales on their completion of 9 and 6 year service. In continuation of the said order, the PSCB also issued a circular dated 20th July 1989, granting the benefit of the first and second time bound higher scales to the employees, including junior engineers too, as per Schedule 1 attached with effect from 1/5/89. Since the PSCB found there was considerable stagnation in the cadre of junior engineers, it had referred the matter to pay revision committee. Keeping in view the recommendation, pay revision, PSCB passed an office order on 29th March 1990. Now, my lord, this was, my lord, what, my lord, was under challenge, and in this context, kindly come to, my lord, paragraph 15. At this juncture, it is pertinent to note that PSCB had already framed the 1965 regulation exercise the powers conferred by Clause C of Section 79 of said Act. Said regulation has been notified in the official gazette. Regulation 17 of the said regulation states that the members of the service will be entitled to such scale of pay as may be authorized by the board from time to time. Thus, in view of Regulation 17 of the said regulation, PSCB was authorized to fix the scales of pay and posts specified therein, including that of junior engineers from time to time. Even otherwise, it is well settled proposition of law that in absence of any rules or regulation governing the service conditions, this is what my learned friend is relying on. Service conditions of the employees, the electricity board has power to issue administrative orders. Now, this is, my lord, a totally, I'm sorry, my lord, to say, totally different proposition of law altogether. And, my lord, I'll just, my lord, kindly look at one judgment, which, in fact, my lord, they had relied upon, my lord, before, my lord, the learned single judge, Consort, which, my lord, clarified this point, relying on, my lord, the T. Kaji judgment.
Right judgment.
T. Kaji, my lord, was a constitutional bench, and, my lord, kindly look at thank you. 1982, they had relied on this, my lord. And I'll show, my lord, the learned single judge, my lord, has considered, my lord, all these, my lord, issues, my lord, in the learned judge's judgment. My lord, this is 1982 to SCC, page 7.
So shown by them.
You had relied upon it. Mr. Sen, in fact, had relied.
Yes.
And, my lord, kindly come to straight away, my lord, paragraph 21 of this judgment. VT Consort.
Yes.
My lord, this was cited by the commission before, my lord, the learned single judge. And you see, my lord, I thought, my lord, this was an absolute, my lord, a very succinctly, my lord, put, my lord, or, my lord, for our, my lord, my understanding. So long as staff regulations are not framed under Section 58(1), it is open to the central board to issue administrative circulars regulating the service conditions of the staff in exercise of powers conferred by Section 7(2) of the Act. In T. Kaji versus U. Jormanik, CM, a district council was constituted under the 6th schedule to the Constitution for the United Khasi and Jaintia Hills district and the tribal areas of Assam. The rules in the 6th schedule empower the district council make laws with respect to various matters regarding administration of the district, including appointment of succession of chiefs and headmen. No law was, however, made regulating such appointment. Even so, it was held by this court that the district council had the power to appoint or remove administrative personnel under the general powers of administration vested by the 6th schedule. Delivering the leading judgment of the bench, Justice Vanchu said that where executive power, paragraph 21, page, where executive power impinges upon the rights of citizens, it will have to be backed by an appropriate law. But where executive powers is concerned only with the personnel of the administration, it is not that necessary that there must be laws, rules, or regulations governing the appointment of those who would carry on the administration under the control of the district courts. So, my lord, my submission is, my lord, all these judgments were not relied upon to say, no, I'm just filling in, are really, my lord, primarily or, my lord, majorly or, my lord, all, my lord, relating to, my lord, really service conditions. And it is not impinging upon rights of citizen. That's one of the first distinction I make. Secondly, my lord, I am saying, and this is our submission, that rule, my lord, section 38(1)(4) requires a particular procedure to be followed, which means framing of regulations with prior approval of the state. So there also, my lord, there is no reason why, my lord, a subordinate, my lord, statutory, my lord, subordinate body, my lord, constituted under the Act would override 38(4) and, my lord, issue regulations really, my lord, which, my lord, may be called administrative decision or may be called advisories, but they're really, my lord, in the nature of, my lord, regulations, regulating, my lord, fixing rates. And, my lord, not only that, my lord, since under the Act, my lord, I've shown they have adjudicatory powers, they are also imposing penalty for not following the advisories. That's the grievance, my lord, we came up with. So though you're saying advisories, but you are actually imposing penalty, saying that you have not followed. That is, my lord, section 45 gives them the power, my lord.
They did not have power to fix that all. Section 19, Rule 19.
Online and আমরা তো 2022 আর ওটা দেখাচ্ছি 2022 and 2015
Decision is initial administration power to say it's not necessary that subject matter fact. Service.
Same thing. Right? These are also service conditions. Which judgment of it's R.K. Deshpande. আলাদা ছিল সুপ্রিম কোর্টটা আছে Perfect. But the decision is useful for the investigation. The product to follow this does not necessarily no action will be taken. Sorry? No, ঠিক আছে System would be that was not his argument on he said section talking about the hierarchy. Regulation doesn't set up constitutional state, the state of position. That is the
Yes, sir. The second point which we urged is on the question that if the section, the act provides that regulations have to be framed or certain things will have to be in a certain way, following the Nazir Ahmed principle, it has to be done in that way and not otherwise. It's not open to the body constituted under the act to really bypass that, ignore the process of framing of regulation by the state, and issue advisor is to have the same effect. And for that, we relied on several judgments were relied upon in the first court, but I just want to rely on two here. This is 2022 SCC online because this is a 2022 SCC online. No, the state of Andhra Pradesh was 2022 SCC online SC 159. And this is an except I don't think there's any, there can't be any controversy with regard to at least this principle. Paragraph my lord 146. It's really my lord reiterating the principle. My lord, paragraph 146. Argument in support of the errata notification dated 13 March is that it is traceable to the powers conferred on the Walk-off Board under 5 of the 1995 Act. Exercise of the publication and notification of the power conferred on the Walk-off Board. Therefore, the fact that second survey report was not submitted to the state government was inconsequent, only a ministerial action. Once the board had the power to publish notification after perusing the various documents, same could not be said to be illegal only for the reason report was not submitted to the state government as contemplated by section 1, subsection 1 of section 5 of the 1995 Act. Argument raised by Mr. Ahmadi that the notification in terms of section 5 is not tenable. It is an admitted case that the second survey report was not submitted to the state government and such report was not even forwarded by the government to the Walk-off Board. Walk-off Board may have a right to requisition of any document in terms of power conferred under section 105 of the Act, but if a procedure is prescribed for issuance of a notification, it could be issued only in the manner prescribed and not in any other manner. The similar so far as our notification, here we have regulations. Reference may be made to the judgment of this court report Babu Varghese is retired. It is the basic principle of law long settled that if the manner of going a particular act is prescribed under any statute, act must be done in that manner, not at all. Origin of the rule is traceable to decision Taylor and Taylor and Nazir Ahmed versus King Emperor. And my lord quotes from there, where a power is given to do a certain thing a certain way, the thing must be done in that way or not at all. This rule has since been approved by the court in Rao Singh Bahadur Singh, 54 SCR, Deep Chand, 62-1 SCR, cases were considered 3 judgments. Then my lord 147, a constitutional bench in a judgment reported CIT Anjum reiterated when a statute vests power in an authority to be exercised in a particular manner, then that said statutory authority has to exercise the same only in the manner prescribed by statute rules. It was held as that. Here, 38.4 clearly says regulation, and when we trace regulation, it is 52, which says with the approval of the state government, if you want to frame, and not inconsistent with the act or the rules. And rule 19 is very clear. And I'll tell my lord why, my lord, that is very important, because my lord, the subsequent judgment which I show, my lord, because I'm just, my lord, make that, my lord, argument in this, and my lord, this 2015 14 SCC 523, similar, my lord, proposition, just, my lord, and this is also, my lord, considered, my lord, by the 2015 14 Supreme Court cases 523. 523. উপায় নেই চিফ জাস্টিসকে যে এড্রেস করছে আমি তো ফিরে বলতে পারবো না সিটি বললে ভালো হতো বলো চিফ জাস্টিসকে যে এড্রেস করছে Yes. Well, this only paragraph 9, it's just similar principle. I don't need just to show. Babu Varghese, my lord, is quoted, my lord, it's a basic principle of law. So, my lord, just the same. Now, my lord, very importantly, my lord, the Bombay, my lord, the Maharashtra government, my lord, had framed regulations with regard to, my lord, rates for private hospital. That was one of the challenge before, my lord, the Bombay High Court. And it held, and which was, my lord, also, my lord, affirmed by the Supreme Court, my lord, the special petition was dismissed, held that even the state doesn't have power. Under, my lord, the Constitution, my lord, regular. Can you, my lord, have a look, my lord? This is and this in fact, this was also noted, my lord, in the one of the orders, my lord, I saw, my lord, in the public interest litigation. Kindly, my lord, my lord, from paragraph. This was cited before the this 2020 SCC Online Bombay 1868 or AIR 2021 Bombay 9. This is also noticed, my lord, in the impugned order. Paragraph 11, 12, my lord, will find on, my lord, the entries with regard to, my lord, the arguments, my lord. Argument, then, my lord. Para 16, my lord, there's a summary with regard to the arguments.
Yes.
And B, my lord, will find, my lord, there was a capping of rates for non-COVID patients as well. And that is, my lord, in bold, my lord, it says this is the extent of challenge in this petition with which we have to deal. 16B. And what C says, first question which we consider is whether entry 6 in list 2, state list of schedule 7 under the Constitution of India dealing with the subject of public health and sanitary hospitals and dispensaries empowers the state legislature to enact any law capping or regulating the rates chargeable by the private hospitals to non-COVID patients, as has been done by the impugned directions. In other words, questions regarding the competent state government or the empowered officer to issue impugned directions. This is not even all a regulatory commission, it's more the state government itself. Second question, my lord, D is second question. আমি এটার পরে কিন্তু সুপ্রিম কোর্ট দেখো আর কি
May I take your lordship's leave, my lord?
Yes.
But I'll reply, my lord, on the next day, my lord.
Reply you want. We thought we can finish today.
No.
Yes.
Because he's the respondent, I have a right of reply.
No, you've got a right. No, we are not saying that you don't have a right,
Yes.
but some other day we can.
Well, thank you.
My lord, if could be finished, my lord, after 2, my lord, I would make a after 2. No. Oh, my lord.
We'll see.
Where? Can you see, my lord, paragraph 17? The first question which we considered is whether entry 6 in list 2, state list of schedule 8 under the Constitution of India dealing with subject public health and sanitation, hospitals and dispensaries empowers the state legislature to enact any law capping or regulating the rates chargeable by the private hospitals to non-COVID patients. None of the learned counsel appearing for the parties could bring to our notice, though put a specific question, any decision either of the Supreme Court or of the High Court throwing light on this question. We have gone through items 1 to 66 in list 2, entry 3. Therein includes the fees taken in all courts except the Supreme Court. Entry 23 therein deals with the power of regulation of mines and minerals development. Entry 32 deals with regulation of mining of corporations. Entry 46 to 62 deal with tax and tolls. Entry 63 relates to rates of stamp duties in respect of documents. And entry 66 relates to the fees in respect to any matters in the list. Similar such entries, including of price control, we find in list 1, union list, and list 3. Thus, we find that wherever the Constitution intended to confer a power on the Parliament or the state legislature to fix the taxes, tolls, rates, charges, fees, or duties specific power is conferred making an entry under the state or union or concurrent list, as the case may be. Similarly, whenever the Constitution intended to confer power to regulate any trade, business, or profession, or such activities or any part of it, such power is specifically conferred under such list upon the Parliament or the state legislation. Therefore, in a view, entry 6 regarding public health and sanitation hospitals and dispensaries in the state list is neither an entry to regulate or control the charges, fees, or rates, nor it can be read to include the power to prescribe or regulate the charges, fees, or rates in respect thereof. We therefore hold that the state legislature is therefore not competent either to frame any law in that respect, or to issue any notification regulating the rates chargeable by the private hospitals to non-COVID patients. Then, they go into the occupied. Second question, whether the legislative field covered by its answer.
There are 22 also.
Yes. Twenty, 19, 20, and 21, up to 21. Well, at least the specially petition from this was dismissed. That's for the records. Yes. And in the impugned order, my respectful submission is there is nothing wrong with the impugned order, which is really followed the law. We'll find that at page at the stay petition that is at page 26. It is 26 and paragraph 2 will find that's the challenge at page 27. The 26 impugned advisory is between 27 July 20 and 7 September, and impugned order is 2nd July, were issued by the Respondent Commission, raised by clinical establishment from patients. Advisory meant for private hospitals and covers the petition number 1. Then will straight away kindly come to paragraph. Then arguments are noted. Paragraph 16 onwards. At page 34. And then kindly just come to the finding is a 33. my lord, page, I don't know if my lord has paragraph 28, my lord, their arguments, my lord, are all noted. And paragraph 32, my lord, is the distinction, my lord, which we had also made, my lord, before the single judge, my lord, paragraph 32.
Yes.
And my lord, 35, my lord, is the Bombay High Court Division Bench, my lord, also noted. And then, my lord, conclusion, my lord, is 39 and 40, where, my lord, the learned judge held that, my lord, there no power, my lord, to really, my lord, deal with, my lord, the situation. My lord, so my lord, my submission is, my lord, that the appeal, my lord, really, my lord, should be dismissed. Also, my lord, I had made my submission, my lord, initially, my lord, on the question, my lord, whether the regulatory body, my lord, itself can, my lord, establish, can prefer an appeal.
Maintainable.
Yes, maintainable. Those judgments, my lord, and relied upon. I'm not, my lord, again repeating, my lord, those judgments. And, my lord, what has happened, my lord, why the urgency, my lord, or rather, my lord, we want, my lord, the appeal, my lord, to be concluded, my lord, whichever way, my lord, is on the question. Because, my lord, we still find that, my lord, the
advisories are issued.
Not only advisories, my lord, we are being hauled up, my lord, for the advisories which have been said to be, my lord,
Penalty is being imposed saying that advice is not being challenged, is not under challenge.
my lord, that, my lord, shouldn't have been, my lord, just give me that, where that advisory 14. Huh? My lord, this is following, if my lord looks at page 2, my lord, advisory 14, my lord, is still, perhaps, my lord, that is advisory 14. We have given something else.
There are two orders.
So advisory 14 is, my lord, what I showed, my lord, in page 119.
Can I have a copy of this? So that I
I'll
can
just
take
give you.
it?
Sorry, the two. Anyway, this is, my lord, only to show, my lord, that, my lord, why, my lord, we are, my lord, wanting, my lord, this to be, my lord,
So this is a decision on a complaint made.
Yes, yes. Relying on, my lord, the advisory 14, saying, my lord, that
Decision on the advisory is about something else. So they said, oh, we noticed that the bill is too much.
and, my lord, that, again, my lord, some more orders, my lord, on the question of, my lord, saying that you give 20% discount, and, my lord, we are on the issue, my lord, that, my lord, this, my lord, advisories, my lord, as, my lord, held, my lord, by the learned single judge, my lord, should, my lord, be.
So next week, we'll have it.
My lord,
I think
my lord, any date, my lord, is fixed, my lord, subject to the convenience of, my lord, the
Wednesday, it will come in the same.
Next Wednesday.
We have already fixed two matters. No?
Thursday.
So today this matter reached because the earlier two matters got adjourned. So once again, it shouldn't get stuck.
Yeah, আমি একটু জিজ্ঞেস করে সর্বপ্রথম I just find out what is happening. ওই যে বলছিস না advisory বেশি order দিচ্ছে, just give me copies.
Madras.
Then what to do?
Madras High Court.
This can be brought on.
Possible, my lord, on Monday, my lord, I don't know, my lord.
Monday we have fixed another matter, the DVC
My
matter.
lord, because this is, my lord, really in reply, my lord, and rejoinder rather, my lord, I do not think, my lord. And, my lord, we all.
Are you
So
sure?
what we'll do is, we'll keep this as a first matter in the specially fixed matters.
আন্দামান যাবেন এখান থেকে করবেন?
From item number 15, specially fixed matters listed, yours is item 17.
My lord.
Next Wednesday, it will come as the first specially fixed matter. so that you can conclude.
Lord, I'm told, Lord, the Learned Advocate General has a circuit bench matter which has got fixed on next Wednesday. If your Lordship would consider Thursday.
Monday,
or
can it be
Friday.
Monday then?
He's going physically or?
No, I
on-
think physically or
No, it's possible on Monday or Tuesday, Malad. Just Malad, because the Learned Advocate General only Malad, I have not cited any new cases. It's all Malad from Malad the Learned.
Would your Lordship keep it
Monday or Tuesday?
Friday week?
Tuesday.
Tuesday.
You please conclude it, Mr. Sen. What you can do is over the weekend, you both of you prepare a short note of
Yes,
arguments. So that
No,
with
note
that,
I will prepare, but Learned Advocate is available at on Tuesday. Lord, make
you are there.
But
Right,
once
my
he's there,
learned
You
friend.
see the Advocate General in you.
no, Lord, once very deeply obliged to your Lordship. Lord, once he is there, Lord, see,
No, on Tuesday, it's not convenient.
Lord, may I just ascertain and come back to your Lordship at 2 o'clock, Lord?
All right, you can inform the court officer. So Mr. Banerjee is appearing for the respondent and petitioner has concluded his submission. For reply submissions of the Learned Advocate General, list on dash. The learned advocates are requested to submit a brief notes on submission on the next hearing.
Yes.
So that will be easier
that
for
will 100%
AG to
Tuesday.
Yes, कुछ नहीं हम जाएंगे तो हमको
Wednesday already I am also don't want it on Wednesday. Tuesday.
So if it can be on 9th April.
Lord, I'll find out. I'll come and tell your Lordship's officer, Lord.
9th April. Subject to Malad.
Subject to
Malad.
Very
Lord,
very deep.
Yes, sir.
Rise, my Lord, may I mention item number 65. Item number 65. This matter has some urgency, my Lord. Next day, next week, my Lord, any day subject to your Lordship convene.
65.
65, my Lord. Today's list, my Lord. Any day, my Lord, next week, subject to your Lordship convenience, my Lord.
My lord. Monday.
Monday.
My lord,
Deeply obliged. My Lord, I have given notice, my Lord. My Lord, may I hand over it?
My lord, similar prayer regarding item number 75. My lord, District Magistrate Malda before your lordship. My lord, this is regarding the matter regarding the health of the common people, my lord. 75. My lord, very short point. I am agreed by an interim order of stay, which was issued by the adjudicating authority, but that order is appealable. Bypassing the appellate forum, they filed a writ application, this nursing home, and my lord, obtain an order of stay, but no, my lord, we do not appear at that relevant point of time. So, my lord, this writ petition at all not maintained by virtue of this stay order.
Then the stay application is still pending before the single bench.
Till disposal of the writ application. I repeated time I mentioned, my lord, they are continuing, the nursing home continuing without any infrastructure, doctor, nurse, patient party regularly complaining, my lord.
It says Malda Apollo Nursing.
Malda Apollo Nursing.
It has got nothing to do with Apollo Hospital.
My lord, what happened, my lord? There we have received. We have receiving a complaint. I am the district magistrate. Complaint from the patient party that without proper infrastructure, the nursing home is going continuing.
So you have issued a closure order.
Closure order.
That has been stayed.
That has been stayed. That order is an appealable order before the adjudication.
That is correct. But suppose there was no opportunity given to the hospital, no show cause.
Given, given.
Can you not seek for vacating the interim order before the?
My lord, I have mentioned repeated times subject to my lord.
No, have you filed your affidavit in the writ petition?
Yes. Everything I have repeated time mentioning, but due to non-content, my lord, 5 minutes maintainability point I will rise. If they satisfied, I have nothing to say.
And who will appear for the respondent?
I have given entire notice and again served notice.
All right, Monday.
Extremely grateful.
Item 75.
Extremely grateful.